Registry Matters is an independent production. The opinions and ideas here are that of the hosts and do not reflect the opinions of any other organization. If you have a problem with these thoughts, FYP.
Recording live from FYP Studios East and West, and I'm in a torrential downpour, Larry. Transmitting across the internet, this is episode 98 of Registry Matters. It is a Saturday night, and it's been raining for like 24 hours, and it's cold. It's like, wow, it's weird here. What's up with you?
Well, it couldn't be nicer here.
I'll trade.
What's the problem you people are having?
I think there's some sort of tropical depression that came up out of Florida and came this way.
That's what I heard. There was a
the weather map looks horrible, man. The weather map is terrible, terrible, terrible.
Yeah, well, we're not having that problem. It's lovely here.
Man. All right. So do you have a guest bedroom that I can stay in?
Sure, as long as you don't mind turning the water on and off every day.
You don't mean at the faucet. You mean at the street, right?
That's actually not quite that bad. I've taken steps to mitigate that.
You have a water leak that you keep trying to fix with putting pipes inside of pipes?
That is correct. And it works.
And your house is 150 years old?
30.
30. This seems awfully young to have that many plumbing problems.
It was a bad product that they put back in the 80s. It was a piping called polybutylene, and it turned out not to be a reliable product for this climate, for the gyrations in temperature we have and stuff. It just turned out that it's been people whose homes were piped with that. It turned out to be a miserable failure, and I was not aware of the piping when I bought the house.
Well, tell me, what do you actually keep doing? And I don't want to sit here for very long. What does this have anything to do with your shower heads?
No, it just that I've got a leak on the cold side, so I turn the temperature of my water heater down so I can run straight hot, because I have one of the pipes turned off that feeds cold into my kitchen and bath. So I'm running just straight hot water, so I have to turn it down so that the water is usable, because there's no way to mix. And it's not that I can't afford to redo the piping. It's that they're going to have to do jackhammers and saws and stuff, and it's going to be such an ugly mess of cutting the walls and trenching through a cement slab. It's just going to be a major disruption. So I hate the downtime of the project. It's going to be an expensive project also, but it's just a lot of mess to deal with.
A lot of disruption.
Mm-hmm.
We have a ginormous amount of content, so I think we're going to end up carrying some of this over to a Patreon Extra, cover a little bit, and just to provide a little bonus content for our super fabulous patrons. So with that, of course, I want to thank all of our listeners, and then a special thank you to our patrons. And we did get 2 new patrons, and we would especially like to thank our newest patron, Steve. Thank you, thank you, thank you. And then an extra thank you to John. Incredibly generous. Thank you so much. Greatly appreciate it.
Well, I'm always astonished of the generosity of the support and the nice people, and sometimes words are not adequate other than thank you to everyone.
I agree. Warms my heart. Well, to start off, we received I guess Jeff wrote in, maybe he voicemailed this in. He says, in my state, and he's in Kentucky, he says, in my state, a man has moved into a house and he is a registrant. There is a sliver of land that isn't being used near the house, so a local prosecutor contacts the city to see about turning the land into a pocket park, for obvious reasons. I'm pretty sure Kentucky is one of a handful of states that does not have a grandfather clause saying that if you are already living somewhere and a park pops up, you get to stay as long as you don't move out and then try to move back in. This is very disturbing to me. First of all, I have a lot of fields around me that could be sold and turned into parks. I doubt it will ever happen because my city already has a bunch of parks and the land is in a very desirable section of the city. I can't see them building a park on such prime real estate, but the fact is that it could happen sometimes makes me worry. I honestly feel like someone was to fight this law in Kentucky. They could win. I would fight it if it happened to me, but I just hope it never happens. But it's disgusting. Very unbecoming behavior of a prosecutor. I'm sure one of the things I have read is that the Sixth Circuit in Michigan has ruled unconstitutional is the residency restrictions. If this court case comes out and it's favorable, it would certainly open up the floodgates for a challenge on laws like this in the Sixth Circuit. And you have an amazing response to all of that, don't you?
I do, and it's a great question, and it's kind of this illustrates one of the reasons why we do want to do this program, because rather than talking to just one person on an old-fashioned phone, I can give this answer to hundreds of people at one time that are across the country in different places listening. And in Kentucky, this issue was dealt with more than 10 years ago. This decision was rendered in 2009 by the Kentucky Supreme Court, and the legislature in 2006 had changed the law that allowed what had been supervised imposed conditions of restrictions of where people could live. They expanded it to the registry at large, and then no one was safe from because there was no grandfathering. He is correct. It said that it applies to everyone. They would be given 90 days to move the people who were in noncompliance. And the Kentucky Supreme Court said, no, you don't get to do that. No one would ever be safe if this. So they analyzed using the Smith versus Doe. One of the provisions, one of some of the dicta in Smith versus Doe was that they found it constitutional because it did not impose any disabilities or restraints. And the Kentucky Supreme Court said that it was difficult for them to conceive how restricted where a person could live did not amount to a disability or restraint. So therefore they said you could not do this to people whose crimes occurred prior to 2006. So depending on if that is still valid precedent, and since I'm not licensed to practice law, I can tell you that I don't find any evidence that suggests that that's no longer valid case law. To the contrary, it looks like it's as solid as it could be, and that a pocket park would do the same thing. It would force people who were already in place to be in jeopardy. So therefore, if I were faced with this, I would cite to the Commonwealth versus Baker case from 2009, and I would say, sorry, you can't tell me to move. But it's very good, solid case law in my opinion, and I don't believe that there would be any retroactive. That would keep people from moving. It would certainly serve the purpose of keeping any new additions or new arrivals, but I don't believe it would result in people being forced to leave that are already in place.
That's good news. And then I think this question came from Dave in Wisconsin, if I'm not mistaken, the second question.
It did.
Okay. This question that I would normally have submitted to Registry Matters because we are the authority on these things. However, several months ago, I decided to take a self-imposed break from the internet and am only using the library's computers for just a few hours a week. It's probably not a bad idea, honestly. Unfortunately, I haven't been able to listen to RM the way I used to, but I still listen to certain segments that interest me. By the way, thank you for touching on the GPS issue in Wisconsin and for talking about online sextings. Several months ago, another justice reform group based in Wisconsin printed misinformation saying that one could take back their plea if they weren't informed of being put on lifetime supervision /GPS. I'm just about positive that that isn't sufficient to withdraw a plea because those impositions are regulatory and not considered punitive, even though they are, of course. Since this misinformation was published and sent via a prison newsletter to about 3,000 Wisconsin inmates, I've received lots of inquiries, very frustrating, and this other advocacy group has not issued a correction and still insists their information is correct. Can you please give me a definitive answer on this? Can one withdraw their plea or not? My research indicates no, and that's what I've been telling other inmates, but I just want to hear it from you.
Well, I'm honored that he would think I would have the answer, but I don't know that I have a solid answer for sure because there are always these variables. I didn't get the opportunity to do full amount of research on Wisconsin. Now, I remember there was a proclamation for their Supreme Court that GPS monitoring is not. I think we covered on the podcast one of our episodes that it's not punishment, and therefore it can be retroactively imposed. I think I remember that. Do you remember us having something like that in some previous episode?
I would say we've had it happen on a bunch of episodes because we constantly refer to it's a civil regulatory scheme.
But I think we talked about Wisconsin in particular. And I think we were in astonishment that they didn't consider it to be punishment, therefore it could be imposed retroactively. But where I would say it gets a little dicier is attorneys, as a general rule, have an obligation to advise of collateral consequences. I believe that's the case of the U.S. Supreme Court case in Padilla versus Kentucky. But they're not required to be clairvoyant and see into the future. So if they properly advise you of what the collateral consequences are at that time, then they've done their due diligence. So I would say that a person who, if GPS monitoring was going to flow from that plea, and it was a given at the time the plea was done, that the person would have a stronger case to make for being able to withdraw their plea, because they would not have done it but for the attorney's advice, and the lack of that information could have changed the outcome. And I'm being so careful because I don't know if that would get you to the finish line of being able to withdraw your plea, since withdrawing pleas are so difficult. But you'd be in a stronger position if the collateral consequence was in existence and the attorney failed to advise or misadvised. And then it comes down to what you can prove the attorney said and whose word they're going to take, because oftentimes attorneys will say that they advised and they didn't, and people don't usually have recordings of their meetings with their attorneys, and they it's just not something where there's enough documentation, and guess who gets believed? And that's why it's best to be done on the record, fully admonished in front of all the collateral consequences should be presented in writing, and the judge should say, now you realize as a result of this plea, there are going to be collateral consequences that flow. Has your attorney explained all those to you? And if the court has a list of those, including you're going to have to register as a sex offender, and with that goes GPS monitoring for whatever class of offenders that attaches to, are you aware of that? Well, then, of course, you're not on very strong. If that's occurred, you're not on very strong grounds to withdraw your plea. So the answer is maybe. This could be misinformation. I haven't seen the article, and I'd like to dig into this again. If he could get the article to us, and if we can get Adele Nicholas, who is litigating GPS, and she'll come anytime we invite her. We just haven't with all the schedule. We just haven't carved out a slot of time for her. But I'd prefer to come back and visit with Adele, who's litigating right now in Wisconsin on GPS monitoring. But the article could be correct, and it could be wrong. So that probably doesn't give Dave the answer he was looking for.
And since he's not listening to the podcast, he might not hear the answer.
But 200,000 other people will.
Very true. Very true. I think we can move over to John, our new patron. He sent in possibly what would be like, Larry, you need to clarify your position on are you an originalist? And do you want me to play the clip first, or do you want to play the clip after you dialogue for a moment?
Well, the clip relates to it because of I believe is he the one that said that I should spend more time on Supreme Court dissents? Was that in that?
That is also that. Yes.
Yes.
Yep.
So that relates to my position on Supreme Court dissent. So I think I'll put the clip into context. I've made comments about not reading Supreme Court dissents, and that's not to say I don't read any of them. I don't read all of them. I don't read them with great interest, because when it's a U.S. Supreme Court dissent, it's of very little use in terms of until there's a change in the makeup of the court. It's not binding. It's not citable for any purpose. Now, if you have a dissent in a state Supreme Court, if a state Supreme Court with 7 justices and you come down with a 4-3 split, you would latch onto that dissent at a heartbeat, and that would be something that you put in your cert petition if they're federal constitutional claims, because you would say, in this divided opinion from the Georgia Supreme Court, and the dissent raised these issues, and that's your bait to try to get cert granted. But when you've gone to the Supreme Court, there's nowhere else to go, and therefore the dissent is all nice academic discussion. But until the makeup of the court changes, and sometimes that can take decades, and you'll hear that in the clip, until that change occurs in the court, the dissent is of very little value. So that's the context to where if I've got a 68-page document, and 40 pages of it is the majority opinion, and 28 pages is the dissenting opinion, since I can't do anything with that, I can't use it to further my case along. I don't spend a lot of time on it, but those who want to alter the trajectory of who's appointed to the court, it would be a good exercise for them to understand where the dissenters are, and if we need more people like those justices who dissented, like for example in Bush versus Gore, where the 2000 election was decided, that reading the dissent would be a good exercise, because even John Paul Stevens, who's no longer on the court, is also deceased, appointed by President Ford in 1975, he dissented in that case. He thought that the Supreme Court got Bush versus Gore wrong. So it's good in that regard, but you can cite Stevens' dissent all you want to, but it doesn't change the outcome of Bush versus Gore.
All right. Well, then here's this clip. And this, interestingly, this comes from Crash Course, which is like a YouTube channel, and they have tons and tons and tons of different channels. And this is from Crash Course Government.
Many Supreme Court cases are not unanimous. In fact, in an ideologically divided court, you are likely to find a lot of cases decided by 5-4 margins. The judges who are on the losing side, who didn't support the majority decision, can write a dissenting opinion. A dissent does not set a precedent for a lower court and has no force of law. But often dissents are very eloquent, and they can provide arguments that might persuade later courts in similar decisions. Sometimes, as with the famously bad case of Plessy versus Ferguson, the arguments in a dissent can form the foundation for the majority opinion in a later case, even though it can take 50 years to get from a case like Plessy to Brown versus Board of Education. So that's the nuts and bolts of how Supreme Court decisions are made. But before we wrap this up, here are a few key things to remember. First, there are a lot of hurdles you need to jump over before a court makes a decision in a case. Most certiorari petitions, there are usually about 8,000 each year, don't make it past the clerks or the Solicitor General and don't get granted. It takes 4 judges to agree to hear a case, but 5 to render a majority opinion. Only the holding and the rationale supported by at least 5 of the 9 justices becomes binding precedent for lower courts. Dissents and concurrences may be fun and interesting to read, especially if there are pictures, and they may include important legal ideas, but lower courts don't need to follow them. So that's how the court works procedurally, but there's another way to think about Supreme Court decision-making. To really understand the Supreme Court, we need to consider the thinking behind judicial decisions.
It's interesting that Chris in chat has then also said, read Ginsburg's dissent in Smith versus Doe. She was right on the money, which leads us right back to the dissenting opinions.
And I have read that dissent, and I'm Justice Stevens was also with that dissent, but it was a 6-3 decision, as best I recollect, and those 3 justices are not. The court has to change before we need to have at least 2 more that agree with that. In the meantime, we may have 2 less if Ginsburg passes away or has to retire. And then what's the name? There's another very old male justice that was around in those days. So it's nice that they dissented, but we don't get anything from the dissent.
And what about your thoughts on the Rankin decision? Isn't that the Judge Mach in Colorado? That was also part of his question. He's asking that in chat as well.
What's the question?
Furthermore, despite the plaintiff's concession in Mellard v. Rankin that the Colorado SORNA survived the intent portion of the Mendoza-Martinez test, Judge Mach squares up to that reality as well. The Colorado General Assembly's disavowal of any punitive intent is an avoidance of any responsibility for the results of warning the public of the dangers to be expected from registrants. The register is telling the public, danger, stay away. How is the public to react to this warning? What is expected to be the means by which people are to protect themselves and their children? The reality of the matter is, if you want to make progress as an advocate for sex offender laws, you need to take on a living view of the Constitution the same way Mach did. Only when a majority of the justices across the country start taking a more data-driven scientific approach to the law, we will get past these as-applied rulings and find something that sticks facially. A Kennedy-Scalia attitude just won't cut it in this day and age, and Larry should read dissents more often. I kind of know where you're going to go with the data-driven scientific approach, because we've talked about that a bunch of times. Public policy doesn't have to be based on evidence or science, or I forgot how you word it.
Yeah, now when I say this, I'm talking about from a constitutional perspective. There's nothing in the Constitution that requires policy that's made by our elected officials to be good or data-driven, or to even achieve the desired stated purpose for the legislation. So whether or not registries are good is not the point on judicial review. There doesn't need to be the data to support that. All there has to be until we get past a rational basis review, which we've talked about the various standards of review, until we get past rational basis, the mere fact that the elected branch of the government wants to do something to protect the community, whether this actually achieves the result or whether data drives it, is not a constitutional test. You don't get to do that. Judges don't get to say, well, I'm going to look for the data to support this, because it doesn't have to be there. There's no requirement. I think that you'd be hard pressed to find anything that says that public policy has to be driven by data and science and all this stuff. Now, that's a different question whether it should be, but it's not required. So if we're going to hang our hat on Constitution, we can't impose a requirement that just isn't there.
I've been trying really hard to think of something where we wouldn't want evidence, or where it wouldn't be important. And I'm almost thinking that even the conversation we were just having pre-show and then this morning about assisted suicide, or your own right to your own life, I don't think that you would find any data driven behind that. It's just, hey, it's your life, do what you want. So we could implement a policy that has nothing to do with it. It's just because we want to.
Well, that's what I was going to say about being an originalist. I am an originalist in one small sense, that I believe that the Constitution presents a floor which we cannot drop below, but it does not present a ceiling which we cannot rise above. And we have a floor. The Confrontation Clause, where I agree with Scalia, who was an ardent supporter of the Confrontation Clause, it's the floor. And despite all the hoopla from the victims' advocates about how it re-victimizes people, until the Constitution is changed, you have the right to confront your accuser. That's something that a floor we cannot drop beneath. Well, I believe, in terms of the evolving part, I believe that we have to look at what the conditions were at the time when these men existed, and they were all men who were involved in the drafting. We have to look at the times that they existed in, and we have to look beyond what they could have foreseen, because they couldn't have foreseen the evolving society. But we would take example of we believe that they wanted the individual to be in control of their destiny, and they did not want the government to be in control of their destiny through laws and an inordinate amount of intrusion from the government. So therefore, in an area of like suicide, if you look at what people died from back in colonial times, they died much younger. I don't know what the life expectancy was. I didn't do the research, but I know that it had to have been at least 15, 20 years less than what it is today, maybe even more. They died at home, or they died in a shootout in a corral in a barroom brawl somewhere. And the medical aid that was rendered was largely some alcohol or something to try to manage pain. But they died without anything keeping them alive. As society has evolved, there are ways to keep people alive that the founders could never have imagined or conceived because of the time they lived in. But if you look at the Constitution and say, well, they were very concerned about the right of the individual to be free from government intrusion, it would be very easy to evolve an additional right. Now, this doesn't mean we can take your life if you don't want it taken, but it would be very easy to evolve into the right of a person to die of their own choosing, rather than being kept alive and hooked to everything, as long as there's somebody to bill for it, so that we can rip off the government Medicaid, Medicare system to keep people. And you can have all the living wills you want, and you can have all the do not resuscitate orders you want. There are hospitals that will not honor them. There are circumstances where you could have a situation where your health deteriorates unanticipated, and you didn't have a chance, or you never did drop such a document, and you find yourself in enormous pain, and they've got you hooked to everything they can to keep you alive. And I believe that although the founders couldn't have foreseen that, because you'd been laying there and they'd been pouring whiskey down your throat trying to get you to expire, I believe that the founders would have said, of course this person has a right to die. And of course, we don't have the right to have a law against, the government shouldn't have a law against a person committing suicide. And of course, we should not force a person to endure agony. I believe you could evolve into that. So I also believe that the Constitution, with evolving society, can be interpreted to take into account what has changed in the last 200 plus years that the founders could never have foreseen.
I would agree. I was driving up I-75 today, and I was thinking, do you think it's possible that Henry Ford, and not that he created the auto, but first to mass produce them, and I'm just seeing mountains of cars coming over in the oncoming traffic, coming over the hill. There's no way in the world he would have ever imagined thinking from his little automated carriage, horse-drawn carriage that's automated with an engine and probably like 20 octane fuel. I mean, it was just terrible. There's no way that he could have imagined what automobiles would have come to today. I'm just making that as a parallel of 100 years even after the United States, the Constitution, and all that stuff. There's no way you could foresee where things would be today without and putting a cap on what can change.
Well, and I think the Supreme Court evidenced my view in the decision they made, and this is a case I can't cite the name of, but it's been in the last 8 years that they decided that searching a person's cell phone without a warrant. There's been the incident to lawful arrest doctrine of searching a person. So if the police arrest you, and the arrest is lawful, not an invented arrest just for the purpose of searching you, the incident for a search as an incident to a lawful arrest of your vehicle and your person has been held to be constitutional because they take the inventory of what you have in your car so you don't come out and say that you had all this stuff that vanished. And then they take the inventory of what's on your person, including your cash and your wallet and your rings and all these things. Anybody that's been arrested knows through what the process goes. That type of search has long since held to be constitutional. But when it came to the cell phone, the case I think was out of California, where they had also searched the cell phone itself, and the Supreme Court said, "Whoa, you can't do that," because the founders would never have anticipated. They were protecting you. Your Constitution protects you to be free from search and seizure of your home and your personal. Well, the phone is not of your person, is it? The phone is not. I mean, we can agree the phone is not a person, can't we?
It is definitely not a person, but the amount of data and information
right,
but
for
exorbitant.
For purposes of this, the Constitution protected you to be the person and their home and their person. Well, the Supreme Court was able to evolve, and I think that decision even was unanimous. That they were they were able to say, well, they didn't have cell phones back then, but what people have in their phones now is equivalent to what they would have had in their home then. Your whole life is many people that I got a youngster working for me. I don't think he has any paper documents. I think everything he has is on the cloud.
I would try to avoid having any paper documents.
Well, and that's what the Supreme Court said. So they looked at, well, the intent was to protect the person so that the cops didn't come busting in their door and searching their home. But they were able to say, well, there has been some evolution in society, and we're now doing something that the founders didn't think about, but clearly the intent was to protect people's privacy. So therefore, we had that old evolution take place where they said the phone is also for purposes of being free from unreasonable search and seizure, the phone can't be searched without a warrant. So when they book you into jail, they should take your phone and they should put it in a property bag. They should not be going through your telephone. Now, I'm not saying they're not doing that. I have no doubt that they're doing it all across the land. That cops are going through the cell phones looking for pictures and looking for hot girls or hot guys or whatever that turns them on. But I'm saying that if they do that, that should be suppressible because if they didn't have a warrant, all they should do is get their personal jollies from going through that because Supreme Court said that without a warrant they can't do that. So I hope that clears up a little bit of my originalism. I talk the originalist line because I know so many of our listeners profess to be originalist and textualist. And I try to point them towards what that would mean in terms of if we had 9 originalists on the court, you probably wouldn't like. And I use Scalia's own words saying that the capital punishment is not cruel and unusual, that you have no right to abortion, you have no right to same-sex marriage. All this stuff is invented stuff, and I want people. I mean, I have no problem. You can believe whatever you want to, but if you mistakenly believe that if we had 9 Scalias, that we would live in happily ever after, and they would have the greatest country, and we'd have the utmost respects for individual rights, I just don't think once you had those 9 Scalias, I don't think you'd be happy with what the court would be finding and what they'd be holding, because he takes a very limited view of what the court should be doing, and every legislative enactment, as far as he's concerned, it's not for the court to second-guess legislative enactments. If that's what the black-letter law says, that's what the text says, that's what the law means. It means what the text says. So if you want people who look at the text and say, I'm a textualist, and by golly, it says you are a person, aren't you? You did move here from Colorado, didn't you? You did have to register in Colorado, didn't you? Okay, that end of discussion. We don't look beyond that. That's what the text of our law says. So that's where that comes out, and I'm actually trying to provoke thought. I'm not an originalist by any stretch, except for I believe that is the floor of where the rights cannot be extinguished. Second Amendment, example of that. I believe that the Second Amendment is not absolute, but I believe that since D.C. versus Heller was decided 10 years ago, that there's clearly an individual has a right to own weapons, and as Scalia said, it's not absolute right to own any and all forms of weapons, but that right is there. So that's a floor we cannot sink below. We have to respect the right of the individual to own weapons until either the Constitution is changed or until D.C. versus Heller is overturned, because that's the state of the law as it exists today. So we can't drop below that.
Well, there we go. That was a 20-minute detour down whether you're an originalist or not.
So, and I am in some limited way.
Thank you, John, for becoming a patron, and thank you for that very elaborate, detailed question, by the way, too. I think you composed that incredibly well. Let's move. You have a Halloween update and also an event happening in, 2 weeks? It's a week, isn't it?
It's closer, a little less.
Oh, it's a week and a half. Okay, it's like 12 days.
So NARSOL would be conducting a Halloween marathon call-in program in conjunction with Axel. And
who is Axel?
Well, who's NARSOL?
Well, who is NARSOL? That's a good question to start off.
The National Association for Rational Sexual Offense Laws. And Axel is the Alliance for Constitutional Sexual Offense Laws.
And why are we joining up, or why are you people joining up with Axel to do that?
Well, this will be the third marathon we've done, and what we're trying to do is to bring the combined strength of the organizations together to bolster the input and the participation and the impact. I believe if there's more people participating, more eyes watching, what we're trying to do is watch the cops. There's a cop watch hotline going to be a part of it. So when people are receiving these knocks at their door and demanding to come in, and particular people who are not under supervision, and there's these large array of officers out in their yards, we want to get some reports, or if they're required to turn themselves into custody to sit it for 4 hours in a location to be detained. We're trying to build a base of what's going on and identify additional causes of action. For example, NARSOL has launched 2 lawsuits in Georgia. We've talked about them, I think, on the podcast before, but we've launched 2 lawsuits in Georgia and 2 adjoining counties, Butts and Spalding, where the sheriffs decided to put up or require signs to be posted by people in the registry last Halloween. And we sent them cautionary letters not to do it last year, and they did it anyway. So we promised that we would investigate and reach out to people in those counties, and we would do our best to file a lawsuit. Well, we've kept our promise. We filed a lawsuit, and we're seeking an injunction to prevent the sheriffs from doing that. Now, the sheriff in Spalding County has already announced, after being served the lawsuit, that he will not be doing this in 2019. But he didn't say he wouldn't be doing it in 2020 or beyond, but he said he wouldn't be doing it in 2019. So we consider that a victory already, because without the lawsuit, we have no doubt that he would have been doing it in 2019. And the sheriff in Butts County has already announced that he's going to do it again. So we're going to do our best to get an injunction to stop the erection of those signs. And then another county called Ben Hill, which I don't even know where Ben Hill County is.
I think it's down by Tifton.
You people have 159 counties in that state. They've announced that they're doing the same thing. So we're getting a cautionary letter out to them, telling them you really don't want to do this. And Ben Hill, if you're listening, you really don't want to do this because we are going to contact all the offenders in your county, and we are going to sue you. If we don't sue you this year, we're going to sue you before you get a chance to do it next year. So you shouldn't, unless you just enjoy wasting your county's money, you shouldn't be doing this. I'd urge you not to do it.
And just for clarity, just to backfill this, why can or cannot a sheriff do this?
Well, in this particular case, there's nothing underlying the sheriff's action. There are states where they have laws that says a sex offender cannot put decorations up, and it applies to everyone on the registry. I think Tennessee, maybe, I'm not sure. I keep hearing from Tennessee, Missouri. There's places where there's in statute. This is not in Georgia statute. This is the sheriff deciding on their own initiative that they're going to impose a requirement that's not in local ordinance or in statute. Now, we see that as a lower hanging piece of fruit to capture. We don't agree with any of them. We think it's hocus pocus, and even the sheriff in Butts County admitted there was an article linking him to saying that the chances of anything happening are so slim. But if you don't have anything, we don't even have to argue about the constitutionality of what's being done, because there's nothing on the books that these departments can hang their hat on. They're acting unilaterally outside the law. So that's what makes these targets more attractive and more vulnerable.
Well, here's something from the article. It's from WFXL, where they one of the people in Georgia shared this, and it says, legally, these signs are placed in accordance with Georgia law OCGA 42-112 I-5, whatever hell that means, allowing the sheriff to notify the community of the presence of sexual offenders.
Well, that's the general sex offender. The statute in Georgia where it says that the sheriff has a duty to inform the community, but that is not a special provision to go out and hang signs on their houses at Halloween.
They could go knock on the neighbors' doors and say, hey, at 123 Main Street, you have one of these people living here, but they can't do anything and come on your property and put up a sign. Well,
they say they can. We say they can't. We'll find out from the federal court if they can or not. But that's a catch-all provision where the sheriff. Again, this is why I want to get registration out of law enforcement's hand, because it is a civil regulatory scheme, and anytime you involve law enforcement in something, there's going to be over-the-top behavior. And if I can't abolish the thing, I want to get it out of law enforcement's hands.
I think that sounds incredibly sneaky on your part, and I like it.
Well, I'm conceding with them for the purpose of the discussion. If it's civil and regulatory, let's take it out of law enforcement. They don't deal with civil regulatory schemes. They deal with criminal schemes.
I understand. It just sounds so devious.
The only thing that sheriffs do that's remotely civil is they serve processes on people who are being sued. Yeah, and then, like in many jurisdictions, the sheriff, some component of law enforcement is involved in dispossessions of people for not paying their rent, and that's done to keep the peace. That's a law enforcement function. And can you imagine if a non-law enforcement person showed up and said, "Well, the court said you have to vacate," and well, what you going to do if I don't? And so law enforcement is involved in those civil, but this is a civil regulatory scheme. It has no business for law enforcement to be involved in, because there's nothing that would require that. The pictures can be taken by a motor vehicle office. Yeah. The electronic notifications can go out to schools. I think pretty much every school has a internet access. I don't know at this late stage of the evolution. Can you think of any schools that don't have internet access?
It would be very strange to think of one that doesn't have one.
So I think that notifications could go out to the affected schools that are within the radius if the statutory scheme requires that. And I think that the internet is quite capable of receiving notices of changes of people's addresses. I don't think that there's any reason for law enforcement to be involved in. And I think that photographs can be updated. I think in fact that you could probably send an updated photo of yourself, and I think that most people's cameras are adequate enough to capture that. And I think I don't think there's any reason for law enforcement to be involved.
Considering I've just been I opened up a bank account, opened up a business bank account, and the amount of paperwork and all that's required, and you can do all of that online. All the federal terror watch list crap that they have you fill out to certify that you're not money laundering and all that stuff. That seems to be a much more stringent set of criteria and you can still upload PDFs and whatnot online. Why can't you just update where you live and update your photo using some sort of app or website or whatever? Why can't you do it that way?
Well, you could. The whole thing is they don't want it that way because they're intended to inflict punishment.
Sure.
And that's why they can't.
Yep. All right, let's move on. We already covered the first article. So the next article is from law.com, and this is kind of a funny title, Larry. This is Defendant Convicted of Watching Porn in Parking Lot Fails in Constitution Challenge to Public Obscenity Law. That is a very bizarre thing that happened. So I guess the short version of the story is some dude is sitting in a McDonald's, not really, parking lot. He was sitting in a restaurant's parking lot, probably just there to use their free Wi-Fi, and he is sitting in his car and he has like a tablet on his steering wheel and he's watching some people do the nasty, and mom parks next door. And my first rule, Larry, is find the parking space furthest away and park there. I don't want to park next to anybody. And then she goes in the restaurant and comes back out, and she goes by and she's hearing noises, moaning noises, and I guess her kid's eyeballs are like glued outside of the window, and he's watching dudes porn in the car. Anyway, I'll let you take it from there, and it all goes south for the guy after that.
Well, the last thing you put about the kid, there was no evidence that the kid even saw or knew what was going on. Just to be clear, yeah, there was no.
But all of the windows in the car were down too.
Yeah, well, that's what was alleged.
That's too funny, dude. So mom goes and takes her kid off to the sporting event, and what goes on from there?
Well, mom comes out of the restaurant and they go to ball practice with the 12-year-old, and then mom calls a friend or texts a friend. I'm not clear which it was, but contacts a friend, and how outraged that she was about something, and the friend calls the police, and the police arrive about 2 hours later, and they find the same condition that was described in the third-hand report. When they come make contact with the person, he's still watching on his tablet, and he starts closing the windows, and the officer observed, consistent with what the report had been, that there was porn. Now, what people lose sight of here, there's nothing illegal about watching porn. There's only certain types of porn that are illegal to watch. And so this case had quite a nuance. First of all, I've passed, I can't even begin to guess how many cars I might have passed going into some place to eat or some place to shop, and I can't imagine that I could find enough energy to spend enough time by someone's window to see the graphic descriptions that she gave of what was on that screen, including the hair color and the actual act they were engaged in. She here specifically, she said she saw a woman with blonde hair performing oral sex on a man, then having sex after that. She also heard moaning, but you could hear that. And during the depiction of oral sex, the mother saw, quote, a penis. The mother became mortified and shocked, as they lived in a small town, and she had never experienced anything like that in her life.
She'd never seen a penis before, apparently.
Well, I don't know how she got the 12-year-old, but so the police dispatch, and they make contact with the guy, and they ask him for identification, and he's not cooperative, which probably wasn't the best strategy on his part to say, I don't have to give you my license, you have no basis to engage me. And it went downhill from that. They brought the canine officer, look for the dog, and look for drugs. I don't think they found any drugs. And he had more phones than anybody I've ever. He had more electronic devices than what I've ever heard of anybody in their life. If you read this, he had. So, since I only carry one, maybe you can enlighten me. Why do you have 4, 5, 6, 7 devices. Can you explain that for us so I understand?
It helps you keep all of your different girlfriends segmented so that they don't, if they grab your phone, then you don't end up ratting on yourself. And I'm speculating. I have no reason. I have like a backup phone just because of my old phone and I never sold it. So I have two.
So
that's it.
Well, pursuant to the search warrant, the police recovered the iPad and cell phone from the front seat, 3 cell phones in the glove compartment, another cell phone from the rear seat, and a second iPad and a laptop from the trunk of the defendant's vehicle. Do you travel around with that much? I mean, you laugh at my shower head. Who do you know that does that?
When I travel on vacation, I will be carrying a cell phone and a tablet and a laptop, but I mean, that's about it. Batteries and power cords.
Okay, well, would you have, it says that police recovered the iPad and cell phone from the front seat, 3 cell phones from the glove compartment, another cell phone from the rear seat, and a second iPad and a laptop from the trunk. That's more than what I carry, but maybe I'm just an abnormal person.
You are, because you have a $30 cell phone, Larry.
99, thank you.
Oh, you upgraded.
So, well, it does everything I want it to do. So,
what happened to dude in all of this exchange, though?
Well, he ends up being charged with a series of offenses, including obstructing the officer and displaying. I forget what all these charges were, but they charged him with 3 different offenses, and he went to trial. He tried pre-trial to extinguish the complaint on constitutional grounds, which were denied, and then he went to trial. And to the credit of the trial judge, they didn't let in a couple of things that would have been even more harmful. He was convicted anyway, but the officer recovered 2 Hot Wheels cars and a Minnie Mouse figurine from the defendant's pocket, but these items were not presented to the jury. Now, when people have heard us talk about 404B evidence, that would be something that a sneaky prosecutor would try to get in because it would be intended to frighten the jury. Why would a 52-year-old guy have Hot Wheels cars and a Minnie Mouse figurine in their pocket except for being up to no good? But if they tried to get that in, which it doesn't say that they did, but if they tried, that was excluded, and that would be why. Because, see, that would have been when we talk about being probative versus prejudicial under 404B, which is a rule that allows prosecutors some discretion in getting prior bad acts in, including prior convictions, but things that weren't necessarily conviction, but it might help them establish mode of operation, motive, a lack of a mistake, planning, something unique about you can bring in something, and a sneaky prosecutor would have said, well, gee, all I got to do is to get the fact that a 52-year-old's got Hot Wheels and Minnie Mouse in his pocket, and they're going to convict him just because they don't like him. Figured he's up to something, might as well lock him up, and make sure that we keep him off the streets. So he gets convicted. Go ahead.
Go. Somebody asked in chat, and Charles asked in chat, why did the police take all of the other devices when porn was only alleged to happen on the one device?
Well, they got a warrant for based on what they observed on when they rolled up into the scene. That formed the affidavit for a warrant to search him because they expressed concern that he might be engaging in other criminality, and that was a question where a judge that was really strict on establishing probable cause, one judge might say, well, I ain't seen nothing here illegal. Why I'm going to let you search it? I mean, he's watching porn, so you got all the evidence you need. You caught him in the act, and so he's being indecent in public. But you hadn't cited me any basis to believe that something of a criminal nature is taking place, so I'm going to deny that warrant. Another judge might say, well, on abundance of caution, a person that's sitting there with a Minnie Mouse and doing this at a restaurant, we better take a look and see what they've got. So the warrant was granted to search, and so they searched the devices. They didn't find anything that amounted to anything on the phones. They found that he engaged in chats, online chats. They found that he was a connoisseur of adult porn sites, but they didn't find anything that amounted to anything. He effectively got probation. He got 5 days in jail and 2 years probation.
And so then he appeals it to try and to squash everything even further?
Yes, he's he thinks he's got a constitutional challenge. Well, let's deal with the warrant. It says the affidavit supporting the warrant. I've got this highlighted, which will be in the show notes. Say there was probable cause to believe the defendant's electronic devices contained evidence associated with child pornography and endangering the welfare of children based on defendant's viewing of pornography at a fast food restaurant in front of a minor. The recovery of kids' toys from the person and the appearance of young girls on his iPad when the officer approached his car. Pursuant to that, a search warrant, the police recovered the iPad and cell phone from the front seat, and that's the stuff. So that's how they got the probable cause based on what the officer observed. But that a judge could have gone either way on that.
Okay.
So, but he's arguing that constitutionally that this statute is void for vagueness and that it's overbroad, and the appellate court decided it was neither.
So he loses and has to stick with his 5 days.
Well, unless he, the state Supreme Court has yet to weigh in. This is the mid-level Court of Appeals. If the state Supreme Court were to, if he has the resources, and the state Supreme Court wants to weigh in, if they grant a cert petition, there could be more to come. But he's kind of on the right track, but he's on the wrong track, because void for vagueness is one claim, and overbroad is another. And that there's an overlap, but they're two separate claims, and he's trying to turn those into one claim. When something's void for vagueness, it's because the language is such that a person of ordinary intelligence cannot discern how to conform their conduct to the requirements of law, and that the drafting is drafted in such a way that enforcement could be haphazard, uneven, and it leads to whimsical prosecutions. And I'm pulling this out, I'm making these words up, but that's what void for vagueness is. An overbroad statute is a statute that reaches into an area where there is no business of the government to regulate. And so he's trying to combine those two into one, that it's overbroad. And the reason why he's tried to do it is because he didn't raise both claims at the trial court below. So he's trying now to cure that deficiency by not giving the trial court an opportunity to address both of those claims. He's now saying that this is one single claim. Now, I'm on his side. I would like for people to be able to watch porn in their car, and I don't like for people to be able to stand by the window and watch it and spend the time that it took to figure it out. And from all accounts, we didn't. If 2 hours went by, nobody else called the police, it was probably not as bad as what this one person described. But the overbreadth doctrine is where the government sweeps too broadly, and they pass laws that are beyond the scope of where they have the right to regulate. And so he's trying to combine those two into one, because he failed to bring them up below at the court below. So that's really all you can do when you haven't done the right thing below, is that you try to cure it by combining it. And so I give him credit for trying, but it didn't work. They said, nope, these are two separate issues. So,
do you think he'll have to be put on the registry?
I didn't dig into that. I don't think so. I don't think so at all. But I don't know that one way or the other. So in terms of void for vagueness, I'm reading from the opinion. A penal statute shall not become a trap for a person of ordinary intelligence acting in good faith, but rather should give fair notice of conduct is forbidden. Clear and comprehensible legislation is a fundamental prerequisite to due process of law, especially where criminal responsibility is involved. Vague laws are unconstitutional because unclear or incomprehensible legislation places both citizens and law enforcement officials in an untenable position. Vague laws deprive citizens of adequate notice of prescribed conduct and fail to provide officials with guidelines sufficient to prevent arbitrary and erratic enforcement. So that's what void for vagueness is.
And something that I read while I was reading the article was that they went and subpoenaed the records of the router at the restaurant, and they found he was looking at porn from there too. That's
probably why he was there. He was probably wanting to use the Wi-Fi so that he could have unlimited porn, I'm guessing. And but the statute the statute provides that a person who knowingly publicly communicates obscene material as defined in section 2C34-3 or causes or permits it to be publicly communicated on property he owns or leases or operates is guilty of the crime in the fourth degree. Well, I wonder if he owned leases or I guess he was operating that property. That vehicle was his where he was doing that. So I guess that's how they swept him in to that.
Right. That's crazy. That is all crazy. And then I'll just point out that if you're going to watch porn, perhaps you should move from one place to another and don't sit there for 3 hours watching porn in your car.
I would tend to concur with that. So you probably ought to try to do porn mostly in private. I would think. You would think. You would think. That seems like that would be that. Generally, people want to do that sort of thing in private, generally, or at least with some sort of consenting partner. Mm-hmm. Not just out there in the open. But I can tell you that I've been driving like in Atlanta or something like that, and somebody drives by and you see porn going on in the screens in the car. So and I just kind of chuckled at it and kept going. Yeah, well, you should have called the police. I should have. It shocked my conscience. He did challenge the warrant and moved to suppress that, and that was denied, and the court upheld the denial of the suppression. And I tell people that suppression motions are, I mean, you do what you can, but most of them go down in flames when you move to suppress something. The trial court was given great leeway, and they decided not to suppress that, and the appellate court under precedent said we're not going to revisit the suppression. And they considered that the automobile stop, which he was already stopped, but the engagement by law enforcement to be reasonable because they said that there was an articulable suspicion that he was doing something that might be wrong. It says the personal observations by the officer, defendant's attention and warrants being issued, even though the officer did not directly communicate with reliable informant, as argued by the defendant. They found that to be enough, to justify the engagement. That there was a report, and that it matched what was what the police officer observed was consistent with what the report was. That was third hand. So he so far he's lost. So. But he got a relatively modest outcome in terms of person who goes to trial. So he did okay in that regard. Are we ready to move on to the next article before we drive like that one for 30 minutes? I think we've done enough on that one. It'll be there with highlights for people the legal beagles that want to look at it. In a couple weeks, we'll be recording episode 100. Larry doesn't know about the surprise that I'm trying to spring on him, or at least I don't think he knows. For episode 100. Mind you, it's a pretty significant achievement to get past 7, let alone 100. I would love for as many people as possible to send in a congratulatory message. It can be super simple and sweet, hey, congrats on 100. Or you can be more elaborate. Patrons of the show, feel free to take as much time as you would like. And please keep it a secret. Shh, mum is the word. And after you've recorded your memo, you can do it with voicemail at 747-227-4477. Or record a voice memo on your phone, and then you could email it to registrymatterscast@gmail.com.
Ready to be a part of Registry Matters? Get links at registrymatters.co. If you need to be all discreet about it, contact them by email, registrymatterscast@gmail.com. You can call or text a ransom message to 747-227-4477. Want to support Registry Matters on a monthly basis? Head to patreon.com/registrymatters. Not ready to become a patron? Give a 5-star review at Apple Podcasts or Stitcher. Or tell your buddies at your treatment class about the podcast. We want to send out a big heartfelt support for those on the registry. Keep fighting. Without you, we can't succeed. You make it possible.
All right. And then this comes from thecrimereport.org. And the title of this is, Where's My ID? Prosecutors get a harsh lesson in post-prison life. I know that we don't want to spend a lot of time on this. This one is essentially an exercise in empathy to try and teach prosecutors what it's like when you get out of prison, and maybe you don't have any ID. You certainly don't have a lot of money. You have so many obligations, and you're carrying around a ball and chain, at all times to try and get to this place, to get to that place, also go to counseling or treatment or whatever, and you don't have money for a bus, and you have to get housing, and by golly, you still have to eat. And they broke out the class into, like, you have 15 minutes to accomplish this task. That counts for one day. And you're going to spend a couple hours doing this to see what it's like to live in this environment for a week. And at the end of it, they're all like, holy crap, that's really hard to do.
I think that's fantastic that this says the paper co-authored by Manhattan District Attorney Cy Vance Jr. There's got to be at least one listener out there that remembers the name Cyrus Vance. And this would be a relative, I'm guessing, son, but I have no doubt this is related to the former Secretary of State in the Carter administration named Cyrus Vance. You remember him quite well, don't you, Andy?
Absolutely, considering I was like 2 years old, or let's see, what was I, 7? I was 10 years old when Carter was in office.
So you remember it just like it was yesterday.
But absolutely, I felt like I was there with him.
But I'm assuming that this is a direct descendant of former Secretary of State Cyrus Vance. But at least this exercise shows that even those who come out of prison with high levels of motivation, the barriers that they're facing, in particular in terms of identification, because the Real ID, which has been on the books now for more than 10 years, I think it passed in 05 or 06 after 9/11. Where that it's very, very difficult now to get an identification or a driver's license because of all the documentations that are required. And this was the big old bad federal government imposing this on the states because of the hijackers. You remember they had state issued IDs that were some were fraudulent. So now they've made it. But the ID barriers are so high, and without an ID, you're just stuck as a non-person, because you can't open a bank account, you can't do so many things, you can't get a job, because first thing that as an employer I'm going to ask you for is your ID, your social security card. I'm going to want to fill out an I-9, and
I was going to say you're required to by law to do the I-9 form.
So I can't do anything with you if you don't have ID, and the hoops are so high. If you've been in prison and say you're born in a different state from where you're in prison at, you have no money, you're trying to figure out how to get that birth certificate that you need, and then they've made it more difficult to get birth certificates because people engage in birth certificate fraud. So they've tried to erect barriers to control who can get another person's birth certificate, and it's just and the expense involved. None of these things are free. I mean, we have people who are incurring a lot of expense trying to get identification.
It is definitely a challenge. And yeah, if somebody doesn't have that some level of support, or somebody looking out for you while you're gone to help you get situated, it is a nightmare when you get out. It is really, really crazy. But so I'm glad that they do stuff like this. I wish more of the people in the law enforcement apparatus, as you call it, I wish more of them would go through these kind of exercises just to give them a modicum of empathy for what happens when you get out.
I wish that, and I wish that states, now we have one state in the country that's pure as the wind-driven snow, and that's Ohio, and they do a great job in reentry. And of course, I'm saying that because one of our board members is from Ohio, and she works in reentry, and she constantly tells me that I have it all wrong, that Ohio does a far better job than most states. So I'm going to give the benefit of the doubt that Ohio does a better job, but I can speak for my state. We do a horrible job on reentry. This is the type of thing where the process ought to begin while the person's in prison. And you can assume that since the longest period of time a driver's license can be valid in this state is 8 years, in some states it's even a shorter period of time, you can assume that if a person's been in prison longer than an ID can be valid for, that their ID is expired. So we could start with that premise. So reentry work ought to begin in terms of making sure that they have those things in place. And we need to have some government funding. I know the taxpayers hate to hear this, but we need to actually have some government funding for reentry assistance, and in terms of helping people procure these documents, and so that they can move forward with their life. And that means case management, and it may mean a budget of the state paying for what people need, so that they have a fair chance to come out and go to work, because you can't get a job with so many barriers already with being a convicted felon, with the fact that everything that you've done in your life is online, but you can't even get to that point because you don't have the prerequisite documents. You don't have the boots to wear for the Harto job where they might. I mean, there's so many barriers, and then we say, why don't you pull yourself up by your bootstraps? You may not even have the boots.
It was also for me personally. By the time I was released, my driver's license had actually expired, and then not only that, but if you didn't renew it within 2 years, they expunged the record. I had to take my driver's test, the actual like motor vehicle test, over when I got out.
So that's pretty funny. That's pretty funny.
I hadn't driven in, 6 years or whatever, and here I am trying to take my driver's test again. Obviously, I passed. Anywho.
Well, anybody can pass in Georgia.
You would think you could pretty much just like put your hand on the road and drive like, as a blind person would. No offense, Charles, and pass the driver's test.
Well, I'm a big believer that once we've punished people, that we also need to be compassionate in terms of helping them transition. And reentry services are sorely lacking, and funds to help people with these barriers are not there. In fact, we do just the opposite. We stack all these charges on people that they can't pay. I mean, financial obligations. When I say charges, I don't mean criminal charges. Well, we stack all these things on them they have to pay. They have to start paying for the GPS monitor. They have to start paying for their counseling. They have to start paying their supervision fees. So we do just the opposite of what we should do.
Yeah.
We set them up for failure.
Yep. It does seem to create that circular door thing for them to come right back.
So
this article comes from the BBC, and it's sextortion botnet spread 30,000 emails an hour. This is super fun, Larry, in that it's what they're doing is they're creating, just like all the other spam email messages that you get. They are sending you a message saying that they have pictures of you doing naughty things, and they actually even insert a password that may have been exposed on on one of these data breaches. So now you're thinking, oh my God, they have my password. So they must have access to my data. And they say that your computer's been all hacked, and they're asking you to pay something of $800, the equivalent of $800 in Bitcoin. And people are falling for it. This is a place where the law of large numbers comes in, and it doesn't matter, if you send out 100,000 email messages and only, you get a 10th or 100th of a percent, you've still made some money, and it didn't cost you very much. Just be aware that people are sending out email messages trying to extort money out of you, perhaps.
Okay, but to me, the Bitcoin would be a clue when someone wants to be paid that way.
Oh, yes.
But what happens to those who don't? That's what I wasn't clear on. What happens to the people who don't pay the ransom? It's kind of like we know with a computer when they tell you that they've gotten control of your computer and your files are locked and they're going to delete them, and if you don't pay them the money, we know what happens. What happens to this if you don't?
I'm pretty sure in this case you like nothing happens, because this is just a scam, and they grabbed a password off of one of the data breaches, and they're just trying to trick you into coughing up a Bitcoin. I don't think there's any. I mean, it's almost like when the people are calling the registrants and they say, hey, we're sending out people to arrest you right now. What happens if you hang up the phone?
Nothing.
Right, but you don't know that. So what happens to these people? Nothing. They're just being extorted out of money for no consequence, but they think there's a threat because they have a password.
Well, wouldn't you just change the password, or where are you locked out? Is that's the part I'm not missing?
Okay. I think even more generally, they're just saying, I know that one of your passwords is password 1, and Larry, you go, oh crap, they have my password. Now, I didn't tell you what I have your password to. I just told you I have a password of yours. And so right. You have, you were one of the 3 billion accounts that Yahoo lost, and they got the password out, and they say, hey, I know your password is password 1. And you're like, shit, that's my Yahoo password. Oh my God, they know my stuff. And so you fall for it.
And then I go change that password to something different, and I say, well, I've cut off whatever they don't already have, right? But they probably already got everything.
If you believe that this would be true, that they have actually hacked into your computer, which I'm pretty sure in this case they haven't, and they're just they're just trying to extort money out of you for literally no consequence. That's the way that the article reads to me. It's just a complete scam, and they don't have access to your computer to begin with.
I see.
Well, there you go. So if you get an email message saying that they have pictures of your junk and your computer's hacked and they do have a password, don't fall for it. This one is,
yes.
Yeah. This one is from, I love the name of this website. It's MyAclamis, or Arklamis, excuse me. So it's Arkansas, Louisiana, and Mississippi is the website. And they have an article talking about that there's a new app unveiled to keep predators away from children in Louisiana. And someone already pointed out that even the title of the article is inverted. It's not to keep predators away from children. It's to keep children away from predators. And the app is this is terrible, Larry, because there's a program, there's a computer trick that people do. They install a Trojan horse on your computer to where they have backdoor access to your machine. And then they can get it, and they can see your passwords, and they can capture your keylogger stuff. This is exactly that. This is a Trojan horse that you are installing on your children's phone so that this watchdog group, this offender watch thing, can keep your kids safe. But now they can see all of the things that your kids are doing, too. This is terrible. And I do have a clip to play for it if you are ready for that.
Let's do it.
Online predators are becoming more clever with technology to target unsuspecting children. Now there's an app that's fighting back. Safe Virtual Neighborhood is a new app that can watch and monitor children's phone calls, text, and social media activity on their smartphones. Here's how the app works. Parents and guardians download the app onto their child's smartphone. The app then monitors and scans all phone calls, emails, text, and social media activity on the phone. Now, if a registered sex offender makes contact with the child, the parent or guardian is immediately alerted from there. Parents are asked to contact local law enforcement and talk to their child about phone safety.
What we're going to do now is take it beyond the physical yard. The internet has expanded to the point where offenders can communicate to your children right there in the living room. The sheriffs have taken a proactive stance, and as the community, the environment has changed, we've been able to adapt new technology to protect children.
Parents and guardians can download the app or learn more at offenderwatch.com.
This is a terrible idea to me, Larry, because you are giving this entity access to see everything that your children do. And now if your children start to do what we often talk about is they start swapping around some nudie pictures of themselves, man, everybody's going to get in trouble for this. Everyone's going to get in trouble.
And people are not going to be able to see that until it happens to one of their kids. Right now, The way that story went down, that sounds like the greatest thing that you could ever imagine. And then we're going to hear complaints about it when we see what you're potentially identifying.
Remind me of this. So you were around when the telephone was invented. What authority do you have when you receive a phone call from someone that you don't wish to speak to? What can you do?
Well, anybody under 25 would never have heard this, but we would say hang up the phone, but nobody uses that terminology anymore.
So where I'm going with this, so if your kid receives, your kid's 12 years old, something like that. My kid's 12. And he receives a message from somebody that he doesn't know and starts talking nasty to him, bullying, sexual, pick your subject. Couldn't we teach him to block it, report it to mom and dad? We don't need an app to do this. You need to have some level of open communication with your kid.
Well, you certainly make a point there, but the argument on the other side would be that kids are vulnerable, and you catch them at a vulnerable moment, and all the teaching in the world, they react to what is it called, grooming? That's something.
Yeah.
You could take a kid who's been well trained, and some kids will still get in cars with people they shouldn't. I mean, they've done those tests and shown that people say my kid would never do that. So you can teach your kid to report and reject calls, but a kid may find something that they receive intriguing. Of course, there's a way you could actually stop it. You could just not have your kids running around with a smartphone. That would stop the whole problem.
It would stop the vast majority of it. It would be tough. But on that though, now the parents have some level of tethering, so to speak, like the helicopter parenting. You don't want your kid running around without the ability to call home and say he needs a ride. So now you give them a phone.
You know, I can only imagine what a school would sound like today with, can you imagine with all the people not silencing their phone and the text and of course I don't even know anybody would actually call a kid anymore because kids don't believe in talking on the phone. But all the text, and can you imagine if a 911 or an Amber Alert or something goes out, not a 911, but an Amber Alert goes out when everybody's phone goes off at the same time? Can you imagine what the classroom is like when that happens?
Yes, I can. At his school, it's a pretty hard and fast rule that you can't have it. I don't even think you're supposed to have it on you, so I think he just leaves it off in the bottom of his backpack. What was I was just going to say something. It also provides an interesting way, though, that you could then know when your kid gets home from school. You can set up some things that would tell you, you can, as the parent, monitor where your kid is, provided the phone is on, and I get that. But yeah, I don't like the idea of saying Offender Watch, install this on my phone so I can keep tabs on what my kid's doing. It
doesn't sound like something I would want either, but a lot of parents are willing to do this because they're fearful of all the bad things that they think that are happening. The things
it's
that are
really bizarre
that are not happening, but that they're convinced that they are. And
yeah, it's totally a false sense of security.
Anything that I can do, one more thing, I would not be able to get over this if there was something I could have done to keep my child safe. Now, of course, you would legitimately feel that way if your child had something happen and you go back and you say, well, I could have done this. We always second guess ourselves about what we could have done. But, the downside is when all this stuff that's being transmitted, what if it's being transmitted from people who are not on the registry, but it's still unlawful? Do they have an obligation to report those images if they're sexting?
Right. And what happens if you get a phone number that happened to be associated with a registrant, and now you get falsely accused of trying to groom some kids because you ended up with a transposed phone number?
Well, that's a good point. And then what happens to the adults when I'm kind of not savvy about phones, but I think I've understood that you can actually see what your kids are doing in terms of you can see the messages and if they're sexting. Is that true? And if so, what happens if like in my state where kids are exempt from prosecution for having images of themselves, what would happen if you had that same image?
I think you're dumb. I think you're done for. I think you're screwed.
But
it's not as easy as that. I don't think it's as if you can certainly go get the information. You can put other kind of watchdog apps on it, but I don't think just hey, it's a kid's phone, therefore you have access to it.
There's no app that actually lets you see what their text message. Because I thought somebody had said I can actually see what my kids are doing on them. So that's
you can set up stuff to do it. It's just not done by default. You can put on monitoring apps and stuff like that would get you that access.
Right, but if they transmit an image where in my state they wouldn't be allowed to possess it, but they would be allowed to possess it, couldn't be prosecuted. But does the parent with that app, do they capture the image that the kid, that when they send their junk?
I'm certain they would. I'm pretty sure that you would end up receiving everything, and now you are done for. That's a terrible, terrible idea.
So parents, if there is such an app, you probably don't want to intercept particularly if you're in New Mexico, you probably don't want to be intercepting any of your teenage kids' text because you might find something that would get you in trouble that if you had it.
Yep. I think, you should handle your child's phone with like latex gloves and a Faraday cage to make sure that nothing leaks out of that, and you just hand it back to the kid and go, I didn't see a damn thing. Have fun. You may want to consider deleting those things, but I didn't see anything.
Mm-hmm.
I think that would be the better way to handle it.
So,
all right. Well, we got some voicemail messages that I want to play for you. One of them, the first one, is from our super patron, Mike in Florida. Are you ready for this? It's pretty long, too.
All right.
Good day, gentlemen. This is Mike, one of your Central Florida patrons. I wanted to call in and make a comment on something that you discussed on the show last week, which was the school using the system to verify people to keep them out of the, entering the school grounds. That's something that Hillsborough County has been doing for a very long time. And I know for a fact that they don't just screen out registrants. They also screen out weapons charges. There's a few other things that they will stop people from entering the school for. I've seen it happen, actually, period. Also, I noticed that on the show you guys were talking about it with your probation, whether they were allowed to go onto the school grounds or not. Down here, if you're not on any kind of special probation or restrictions, you're allowed to drop your kid off, pick your kid up. They just won't let you inside the school. I just wanted to throw my 2 cents in on that. Also, one more thing, I had to re-register this morning, and when I did, they are handing out little flyers reminding people about Halloween and the special restrictions you have, and they will be watching and enforcing it. And I just figured I'd ask them how many cases they had and how many problems they had with Halloween and anything going on with Halloween. And there was 4 deputies that were in the vicinity, and I asked them all, how many problems have you had? And I did not get one response. They couldn't think of one time anybody had done anything or they had any issues, period. Yet they're still pushing the hysteria as usual. Other than that, I really enjoy the podcast. I'm a huge supporter, big fan of you guys, always love the content. And I just want to say keep up the good work, and I'll keep supporting you guys. And I just wanted to wish a big old Halloween special FYP to all the people who hate on us, and love you guys. Take care, and I hope to hear from you soon. Keep up the good work.
Thank you very much, Mike. So very much appreciate his long-time support. I'd have to go back and see, but it's been almost for forever.
It has, and I appreciate that because it clears up what the article that we were talking about was one from Georgia, from one of our supporters who said that could no longer go on school grounds. And I took issue with that because I was saying, how would they know that you're on the grounds? Very few schools are set up for monitoring the grounds, but they are set up for monitoring the buildings and access to they've centralized. Most schools of any size have centralized, and they have electronic, they have cameras, they buzz people in. It's a lot different than it was back in our day. And so I can understand how they would keep you out of the school building. But in terms of pulling through the circle drive around through the school, I do not know of very many schools who have closed campuses where they have guards and they say, okay, you're getting ready to come on campus, master your ID, please. I just don't know of very many schools that do that. So he clarified that you can go on the school grounds to pick up your kid, but you can't go in the school building because they're going to run you at that point. And that was the point I was trying to make. That I think that thing in Georgia was an overreaction because they can go still pick their kid up at discharge time, but they couldn't go pick their kid up possibly if they're going to go in the building to check the kid out, because they may not let them in the building, or once they get in the building, they may say get out. But in terms of, I don't see how they'd ever keep you from going on school grounds, because few schools are set up to monitor who's on the grounds.
Yep. I do understand and agree. And now it is time for a voicemail message from Charles, which is sort of related to the pornography in the car situation. It's at least sort of similar. And here is Charles.
Here's a question, and it was inspired by a conversation with a friend and I. I was at an appointment in a building, and I was on the 10th floor, and we were in the waiting room, and my friend was looking through the window of the waiting room and was commenting how he could see into the opposite building. He could see into someone's apartment, and he was commenting how they had a messy apartment. And he made the comment, about how fortunately no one's walking around naked in there from the shower or, something like that. And which inspired the question, is it a crime for someone to be walking around inside a apartment naked where people in the opposite buildings could see them? Is it, is that illegal? Is that a crime? FYP.
I think it's a great question.
I do. I think it's a great question, and I don't know the answer to it because you have an expectation of privacy in your home, and there's an expectation that generally you can do many things in your home that you can't do in public. So if you're walking around naked, I would argue you have the right to do that. can they force you to close your window shades and do that without anybody being able to see in? Yeah, my answer is to people: if you don't want to see what someone's doing, don't look in their yard, don't look in their windows. You could pass me and I'd never recognize you because I'm not paying very much attention to who I'm passing and what's happening around me. I would be the most vulnerable person in terms of I have no idea who's around me, what's going on. But I don't know if they could prosecute you for any type of indecent exposure. I guess it would be very nuanced in terms of, were you making an extra effort to be seen? Was there a reasonable expectation that minors could see you? Did you get up to the window and dangle it? And I mean, I think it would be very nuanced, but I don't know of any particular laws that says that you can't be naked and running around nude in your house. None are coming to mind, but I wouldn't put anything past. There might be such a law.
I'm inclined to say, man, you can run it. I think that I'm inclined to think that inside your house, if you leave them open, obviously you have some voyeurism and what's the word I'm looking for? I can't think of the word. Exhibitionist tendencies, but stop looking in my windows then. I have the windows for me, not for you.
Yeah, but see what the little old prude would say is, well, I have to get fresh air every morning because I've got asthma, and I open that window up, and the first thing I see is this person dangling his pallywhacker out there, and he does that just to get at me because he knows that I have to get a breath of air in the morning, and that ain't right. I shouldn't have to endure that, and I want something done about it. That would be the other side of that.
Wow. Tallywhacker. You're too funny, man. Oh, my God. It's probably time to shut it all down. What else do you have besides that? I should leave that for the Patreon content because that's silly.
Well, all right. Well, I don't have anything else for this segment.
Oh, and Larry, before I forget, I wanted to mention, I know that we covered this last year and we may have talked about it this year, but Will is a longtime listener and also a Patreon supporter, and he hasn't been able to go to church. He has some sort of 10, 12-day prohibition on being outside of his house after curfew. Anyway, he, as I understand the story, he reached out to the ACLU and they wrote a letter saying that this violates his constitutional rights. And he gave that to his handlers, and they said, hey, you can now go to church and Bible study and so forth. You can attend church functions, during this little Halloween window.
That's that long festival period they have in Tennessee. It's like a 10, 12-day period where they put great restrictions. And I'm still not able, with all the research I've done, to find that there's any statutory authority for people who are not on supervision. But this listener is on supervision for life, as I remember, but the kudos go to the ACLU, being the deluge of requests they get, and people can't fathom how many requests they get, because everybody that hates the ACLU, which is the bulk of the population, I mean, their membership is 1 million people out of 330 million, and it's only done that since Trump's been elected. Their membership has actually grown exponentially since 2016. But the resources they have are just so minuscule compared to the civil rights violations. So for them to take the time to do this, what it tells me is that they see a potential win in this area, because if you can't win on separation of church and state, then you can't win on anything. And I think
that sounds fair.
I think that they see a potential here for. In fact, I would say they'd be just as happy if the state had told them to go pound sand, because they might actually initiate litigation. This is one of those things where when you're analyzing your business model, and the ACLU is a business, it has employees, it has expenses, and you're analyzing what you can do with your limited resources. Winnability is something that you consider, because you deploy your resources just to have fun, or you deploy your resources to make a difference and advance the body of law. And the separation of church and state is something they're big on. That's one of their priorities. They do not believe that there should be Ten Commandments, and Will might disagree with that. They don't believe that the church and state belong together. So this is where they're being at least intellectually honest. They're saying, hey, guys, although we're not big religious proponents, we also don't believe you should have the right to interfere. That wall of separation's there. So, Will, it's a great achievement that you were able to get their attention, and they were able to do that for you. And hopefully the fact that they received the letter from the ACLU, and what I don't know is if it went to some central state official or if it went to a local official, how much impact it may have beyond Will individually. But if it went to a state official, it might trickle down to others who are in the same situation that would like to worship during that 10-day period of time.
And do you think that then has persuasion for others?
What do you mean by persuasion?
I mean, like I'm sure that only applies to Will, but then doesn't that transfer over to?
Well, that's what I'm saying.
Could potentially.
If he's in Podunk County and they run the office locally, and only the local people in Podunk County receive that, then it probably won't have much impact outside of Podunk County that has 14 offenders under supervision. But if Tennessee is set up where they have a statewide system of supervision, and this letter went to someone high at a state level, it may very well trickle out. They may actually communicate to their field supervision office, hey, we got a letter from the ACLU that says we got to back off on this because we got to let people go to church during this 10-day period. And so it could very well have impact if that's what you're meaning. It depends on who the letter went to, and I don't understand who the letter went to. I haven't seen a copy of it.
Very good. Well, congratulations, Will, and hopefully that does spread.
If Will has a copy of the letter, I'd be happy to talk about it on the next episode.
I do. He sent me a copy.
Well, let's have a look at it.
Let me track that down. I will drop it over in the Dropbox.
Take a look at it and see what it says. So what else do we have on this special segment?
After you read that, then we can move on to the Patreon-only stuff.
Let's take a look at this. Oh, this went to the highest levels. Commissioner Tony Parker, Tennessee Department of Corrections. This may very well be, so it's a longer letter. We're not going to read it, but this very well could have impact. And at first glance, it looks like they did a good job composing the letter. So they concede while protecting children generally is a legitimate state concern and has traditionally entailed certain additional restrictions around the Halloween holiday. Restrictions such as a 12-hour curfew not only affect the liberty interests of an individual, but can also have collateral effect on the rights guaranteed under the United States Constitution. That's cool stuff.
Very good.
So, and courts have affirmed in the next to last paragraph, an individual status on the registry does not deprive them of constitutional rights. And then they cite Doe versus City of Seaby Valley, a federal court invalidated Halloween sign requirement, which I think Janice was involved in that case. Janice Bellucci, that is. So, good job, Will. Good job.
Did the Georgia attorney cite any of that stuff though?
Well, there were few citations in the complaints that were filed because there's no authority whatsoever for what's being done. Apparently, there's something in Tennessee that's authorizing this. It may be policy, but there's something underlying this. The Georgia sheriff just pulled that out of their what.
Yeah, I do.
So Tennessee has something backing it up, and I don't know exactly what it is.
Very good. All right. Well, then how can people find the podcast?
They can search very carefully in their browser, and if they go to registrymatters.co, they'll find us.
And we did get some voicemail messages, like a whole plethora of them. And what's the phone number to reach us?
747-227-4477.
Of course. How about leaving some email messages?
registrymatterscast@gmail.com.
Finally, our most appreciated and best way to support the podcast is
patreon.com/registrymatters. And that's PATREON.com.
Very good. And to those of you that aren't patrons, if you want to get the extra content, $1 a month would get you this bonus content. And we're going to let it hang loose a little bit. Maybe I can get Larry to actually cuss on the air. And otherwise, you guys have a great week. And I will talk to you soon, Larry. Good night.
Good night.